And hello, everyone. Welcome back to the Standing Committee of Fisheries and Oceans for hearings today. We're going to have 2 hours of hearings. We have our guest with us, and of course, as we mentioned before, this is a review of changes to the Fisheries Act pursuant to Standing Order 1082 and the motion adopted by the committee on Monday, September 19th, 2016. The committee resumes its study today to review changes made to the Fisheries Act. That being said, now we'd like to go around to our witnesses. We want to welcome our witnesses. And we have from the Canadian Independent Fish Harvesters Federation, we have someone who is no stranger to this committee, Monsieur Marc Alain. Good to see you again, sir. And Graham Gon as well, also from the harvesters. There'll be one group, 10-minute presentation. From Lake Ontario Waterkeeper, Mark Matson. And also we have Kristen Tully, who is Vice President. Mark Matson is President, by the way. They are joining us by video conference. From the Mining Association of Canada, we have Justina Laurie-Lean, who is Vice President, Environment and Regulatory Affairs. We also have Mark Ruthven. I hope I pronounced that correctly, sir. Yep. Okay. He's the Associate Biologist at AMEC, Foster Wheeler. And also from the World Wildlife Fund, we have Elizabeth Hendricks, who is Vice President of Freshwater. We understand that Mr. Miller could not be with us today. He was originally scheduled. David Miller, I speak of, who is the CEO or President? CEO. We wish him the best. Unfortunately, couldn't be with us, but Ms. Hendricks, it's good to have you here on behalf of the World Wildlife Fund. So normally how we do this, we get a 10-minute presentation each, up from each group. So I will look to you to choose your spokesperson. Mr. Alain, will you be speaking on behalf of the fish harvesters?
I'll be sharing my time, Mr. Chair, with Mr. Gon.
Very well. Very well, sir. You may start with your 10-minute presentation.
Well, thank you. Thank you, Mr. Chair, and thank you to the members of the committee for inviting our federation to testify on this very important topic to our members. Our federation is a national organization of associations who represent men and women who fish for a living, own and operate their own boats, and live in fishing communities. In Atlantic Canada, our owner-operator fleets generate roughly $2 billion a year in landed value. That's $2 billion that goes directly into the pockets of fishermen and is spent in small fishing communities. This money drives fishing communities on our coast, communities that often have no other resources or industries to support them other than tourism. I would like to address the first part of your mandate, which is to review the scope and application of the Fisheries Act, and my colleague, Mr. Gon, will address our concerns about habitat protection. As was suggested by the Minister of Fisheries and Oceans when he appeared before you recently, we would like you to take a holistic and sustainable development approach to the changes to the Act that are needed to restore our lost protections. 40 years ago, when we created the Department of Fisheries and Oceans, we took a holistic and sustainable development approach to our fisheries as a country. Our first Minister of Fisheries and Oceans, the Honorable Romeo Leblanc, understood that we have fisheries for a purpose, and that this purpose should be to generate social and economic benefits to the fishing communities and to the people who fish. Mr. Leblanc protected fishermen and fishing communities. He understood that sustainability is a three-legged stool with ecological, social, and economic legs. Mr. Leblanc did two very important things. He put limits on corporate concentration in the fishery, and he made sure that a fishing license was a license to fish, that the people who received fishing license for our coastal fisheries had to be owner-operators. Mr. Leblanc was a man of vision, and his vision worked, especially in Atlantic Canada. His policies freed fishermen from company control and lifted them out of poverty and into the middle class. Since then, independent fishermen and fishing communities have lost ground. The department has moved away from a holistic, sustainable development approach to our fisheries and become narrowly focused on only one aspect of sustainability, the conservation and protection of fish. The Fisheries Act has become a one-legged stool. It tells us a lot about conservation, but virtually nothing about our social and economic objectives for the fishery. You may be surprised to learn that the Fisheries Act does not have a statement of purpose. The purpose of the section is Section 2, and it was repealed in 1985. And now we have a Section 2 that says purposes, and the rest is blank. This is something that needs to be fixed. Our Fisheries Act needs a clear statement of purpose. The Fisheries Act should say why we conserve and protect fish and fish habitat. We have some specific recommendations to make on how that might be done. I believe you received this, but I'd like to table the letter we sent to the Minister of Fisheries 2 weeks ago, outlining the details of our proposal. In summary, though, we believe it's critical that the purposes section of the Act clearly establish the authority of the Minister to manage the fishery in pursuit of cultural, social, and economic objectives, in addition to the conservation and protection of fish. The absence of such a clear statement in the Act creates an ambiguity regarding the scope of the Minister's authority. This is very, very, very important. And the government can correct this by drawing on rulings of the Supreme Court of Canada and the Federal Court of Appeal, as the courts have been very clear and very, very consistent on the broad scope of the Minister's authority to manage for social and economic objectives. In your letter, you'll see that we propose changes in other sections of the Act and the fisheries regulations to make the relevance and legitimacy of social and economic objectives for fishery management very clear. That wasn't planned, Mr. Chair. It takes a few seconds, but I'm running dry. We'd also like to see the owner-operator and fleet separation policies and regulatory reform to give them the force of law. This is something we've been asking for 20 years. And we were promised it in 2004 by the Honourable Jeff Regan, you know where he is now, when he was Minister of Fisheries, when he announced the policy framework for Canada's Atlantic fisheries. In black and white regulatory form for owner-operator fleet separation. We're still waiting. There's a broad consensus amongst fishermen, fishing communities amongst the provinces that fishermen's independence needs to be protected. In 2012, the legislative assemblies of New Brunswick, Nova Scotia, PEI, and Quebec all adopted unanimous resolutions calling on the federal government to maintain the owner-operator and fleet separation policies. And a few weeks later, the Federation of Canadian Municipalities adopted similar emergency resolutions. I just want to end with a comment on the urgency of the situation. We have just come through a very, very long period of neglect of our social and economic objectives for the fishery and for fishing communities, and much damage has been done. In British Columbia, a federal fishing license is no longer a license to fish. It has become a license to tax fishermen. The situation is bankrupting independent fishermen and destroying the fishing economy of BC's coastal communities. The problem is not restricted to BC. Despite the owner-operator and fleet separation policies, the same thing is happening in Quebec, the Maritimes, and Newfoundland. There are ways to fix this, and we hope we will see our concerns and proposals reflected in the committee's report to Parliament.
Good afternoon, Mr. Chairman. I'm Graham Gaughan. I've been an inshore multi-species fisherman in southwest Nova Scotia for over 40 years. Mr. Chairman, members of the committee, no one can have more concern for the health of our marine resources and the sustainable management of them than those closest to them. Those resources depend on a pristine environment, as do our livelihoods as fishermen and the well-being of our fishing communities. For as long as I've been a fisherman, fishermen's organizations have been at the forefront in making public our very reasonable concerns about protection of fish habitat in the face of projects proposed by others for our waters. Where I come from, we have the Clean Oceans Action Committee, a coalition of organizations made up of 9,000 fishermen, processors, fish workers, and associated trades. Our committee has the unanimous written support of all municipal councils in our region. This committee is raising broad-based community concerns about oil and gas exploration on the Scotian Shelf, concerns we've been raising since the no-rig campaign of the 1990s that led to the moratorium on exploration on Georges Bank. When we go before the government agencies that are responsible for regulating this activity, like the CNSOPB, we are met with blank stares. In this case, we don't seek to block such projects, but we do insist that there be some objective, independent oversight on the environmental impacts of these projects on our fisheries and our communities. We need assurances that reasonable environmental precautions, monitoring, and response plans accepted by the affected communities are in place first, as well as a guarantee that our fisheries are protected from any collateral damages caused by these projects. What we're asking for is already part of the government program. This government's own policy statement on environmental assessments states that we will make environmental assessments credible again, and it further declares Canadians must be able to trust that government will engage in regulatory oversight, including credible environmental assessments, and that it will respect the rights of those most affected. While governments grant permits for resource development, only communities can grant permission. With the environmental and social protections that we have lost, we've also lost our trust in government. So restoring lost protections must also restore our trust that government is working to protect us, our communities, our environment, and the economy it supports. For us, restoration of lost protections means restoring Section 35 as a trigger under the Canadian Environmental Assessment Act. Without the trigger of Section 35, fishing communities, coastal fishermen, and the ocean floor no longer have full protections from increasing uses of coastal marine environment by other industries. Activities such as dredging, pipelines and cables, aquaculture operations, renewable energy operations all impact fish habitat and must be subjected to very careful environmental impact assessments before being approved. In the case of oil and gas exploration on the Scotian Shelf, some of our most important marine conservation areas find themselves with drilling rigs on their very borders, at the same time as we fishermen are being told to protect more areas to meet the government's commitments for MPAs. This is puzzling to us. We see several alternative energy projects operating, experimenting, and being proposed, often in sensitive areas, including wind and tidal power, and expanding ocean aquaculture plans in areas that we think should be protected. These projects, as innovative as they may be, must not be allowed to threaten or risk harming the marine environment, which sustains tens of thousands of jobs and a renewable resource that injects billions of dollars into the economies of hundreds of coastal communities, and indeed that of Canada. Just for the record, we independent inshore fishermen consider ourselves part of that ecosystem too. The Fisheries Act should be Canada's strongest environmental law and a key tool for regulators responsible for protecting the environment. In terms of lost protections, we would like to see a restoration of the wording of the Act concerning the harmful alteration, disruption, and destruction of fish habitat, as it served us well in the past. We are also asking that under the scope of restoring lost protections, you fully consider the changes to the aquaculture activities regulations. For fishermen, the use of pesticides in open net salmon farms poses a direct and significant threat to our coastal lobster fisheries, the most valuable fishery in Canada. The pesticides that the aquaculture industry uses to kill sea lice don't discriminate. They kill crustaceans. They kill lobsters too. In the past, Environment Canada successfully prosecuted the aquaculture industry for illegal pesticide use. The changes brought about by the aquaculture activities regulations diminish the prospects of these kinds of protections in the future. We want to see those restored as well. I want to close with comments about the broad scope of the protections we've lost and need restored. In the last 2 decades, our coastal communities and the independent fishermen who live in them have been facing an assault by corporate and foreign interests seeking to gain control over our independent owner-operated fisheries. Corporate interests have influenced officials to bend, alter, ignore the critical fleet separation and owner-operated policy to allow them to gain control over our licenses, effectively siphoning the earnings of our inshore fisheries from those coastal communities and into corporate treasuries. In Nova Scotia, where I fish, thousands of inshore seasonal owner-operators have effectively been disenfranchised from their traditional fisheries in the drive to privatize as the government looked the other way. This is not good public policy. It is wrong that this is allowed, and the DFO seems unwilling or is unable to deal with the problem. We look forward to your report and recommendations to Parliament on how to restore our lost protections and our confidence in government. Thank you, Mr. Chairman.
Thank you, Mr. Gahn. We're now going to go to video conference. We have Mr. Madsen and Ms. Tully. Of course, you have 10 minutes. And who will be doing the presentation?
Thank you, Chairman Sims. Mark Matson. I'll be starting, and again, I'll split my time with Ms. Tully. Good afternoon, and sorry we couldn't be there with you today, but this seems to work fairly conveniently. So, people in Canada are more likely than any other nation to say that they value water and nature. And yet, Canada ranks lower than most developed nations when it comes to key environmental protections. It wasn't always this way. Canada's environmental descent is a relatively new phenomenon prompted by a decade of deregulation and the failure of governments at all levels and on all political stripes to set policy goals that reflect people's need and desire for swimmable, drinkable, fishable water. The Government of Canada's review of the Fisheries Act, Navigable Protection Act, Canadian Environmental Assessment Act, and the National Energy Board is a chance to put Canada on the right side of history. It's time to realign federal law and policy with the values shared by the people all across this country so that communities can prosper. I'm Mark Matson. I'm here with Kristen Tully, and our organization is Lake Ontario Waterkeeper and Swim Drink Fish Canada. And in total, we represent 1 million people who care about swimmable, drinkable, fishable water. We participated and commented on every major change to the Fisheries Act in the last decade, including the Omnibus Bill, brief as they were, in 2012. Prior to that, I was a lawyer and investigated or prosecuted pollution offenses under the Fisheries Act privately and with the governments in Kingston, Hamilton, Deloro, Montreal, Port Granby, Moncton, Toronto, Happy Valley Goose Bay, Sarnia, and Vancouver. The Fisheries Act was once at the heart of our work at Lake Ontario Waterkeeper because we gave meaning and force to environmental law. An estimated $2 billion is being spent on restoration today in many communities across Canada. When the law was changed in 2012, proponents argued there would be no impact on fish or fish habitat. We disputed those claims at the time, as did most experts. It is now clear that the changes do impact fish and fish habitat. What was once illegal is now legal. What was once prohibited is now permitted. It is our position that the existing act is so deeply flawed that there is essentially no federal protection for fish habitat or water in Canada. And our presentation today focuses on the 9 things a new Fisheries Act must do if Canadian communities are to thrive. Kristen?
So 9 things the new Fisheries Act must do to make Canada healthy and prosperous. First, protect fish by protecting ecosystems. Some of the most devastating changes to the Fisheries Act were the cuts to habitat protection provisions previously found in Section 35. The changes were not rooted in science, traditional knowledge, or even common sense. In an ecosystem, all things are connected. Fish cannot be protected if their environment is not protected. Legally, this shift is also problematic. Traditionally, the Fisheries Act placed the burden of proof where it belongs, on the proponent. The proponent had to prove their project would not harm fish or fish habitat. Today, that burden rests on government and residents. And ultimately, the changes made to fish habitat provisions in 2012 will ensure that the Fisheries Act fails to protect any fish in Canada. Those changes must be reversed. 2, we must simplify the rules against pollution. The pollution prevention provisions in the Fisheries Act once made it Canada's most important and effective environmental protection law. Section 36(3) once protected water from pollution by prohibiting the deposit of deleterious substances into water. Thanks to small changes and new regulation-making powers, the Fisheries Act now allows government to do by regulation what parliamentarians didn't dare do: eliminate federal protections for water quality. We see the impacts already, from sewage to aquaculture. This shift is problematic because the Fisheries Act was designed to protect water quality without requiring an itemized list of what substances and what amounts under what conditions could be considered deleterious. This is the only efficient way to ensure the Fisheries Act remains relevant over time and protects all communities equally. Microplastics, triclosan, certain pesticides, fire retardants, those are all examples of substances we know to be deleterious, but were invented after the Fisheries Act was written. That was the beauty of the previous act. The traditional deleterious substance test must be restored to the heart of all pollution prevention provisions. 3, the Fisheries Act needs to embrace the precautionary principle. When there is uncertainty, decisions should favor the protection of fish and fish habitat. Fish are part of interconnected ecosystems. We can only partially understand. The consequences of one change or a project cannot always be predicted. Emerging issues such as the invention of new contaminants, cumulative effects of multiple projects in one area, climate change, shifting land and water uses, population growth, these make it virtually impossible to predict impacts with any certainty. And for that reason, the principle of precautionary decision-making should be part of the Fisheries Act. 4, ensure Fisheries and Oceans Canada and the federal government remain responsible and accountable. The Fisheries Act must affirm the federal government's authority for protecting fish and fish habitat equally across Canada. Section 4.1 of the Act, for example, doesn't belong in a federal Fisheries Act. Provinces should not be empowered to encroach upon federal jurisdiction. And within the federal government, Fisheries and Oceans should also not cede responsibility to other departments and agencies. 5, protect the natural resource, not industries. The Fisheries Act had one purpose: protect fish and fish habitat in Canada. Changes have been made to the legislation that shift its purpose away from protections and towards permitting pollution and habitat destruction, especially by favored industries. You can see this in the exemptions now being given to mining, sewage, and nuclear projects. 6, eliminate self-regulation. Self-regulation is not appropriate to ensure compliance with a quasi-criminal statute. The federal government must be responsible and accountable. Because self-regulation cannot protect fish and fish habitat, it can't prevent cumulative impacts, also known as death by 1,000 cuts. It doesn't allow for public participation or take advantage of local knowledge, and it will not catch the truly bad actors who are doing the most harm. 7, support a strong environmental assessment process. We recognize there's a federal panel reviewing the EA processes. We support efforts to improve that legislation. The Fisheries Act should be part of a federal government culture of environmentally responsible decision-making, transparency, and public participation. 8, empower the civil service to enforce protections. There must be sufficient funding and staffing for enforcement activities. Enforcement officers should report to an independent supervisor, such as the Attorney General, to avoid the influences of regulatory capture. For the most part, the Fisheries Act once did all of these 8 things. And our final recommendation is to add something new. 9, promote the development of scientific and traditional knowledge. The way forward isn't just to patch the Fisheries Act and hope for the best. The Government of Canada's goal shouldn't be to prevent the deaths of a few more fish or to restore a tiny fraction of the tiny fraction of habitat that we have left. The goal should be to become a world leader in the protection of fish and fish habitat. The way forward is to develop a knowledge base that can inform not only Canadian decisions, but decision-making around the world. We should be investing in scientific study, commercial research, and traditional knowledge to become a world leader. Knowledge, not oil, trees, rocks, or water, is the greatest gift that we can offer the world. Committing to sustainability and informed decision-making will drive innovation, and that is the foundation for Canada's prosperity. Thank you.
Those are our submissions, Chairman Sims, and we'll wait around for questions at the end of the other submissions. Thank you.
Well, we thank you for that, and we'll address that in just a few moments. We have 2 more presenters. Right now, we're going to the Mining Association of Canada, Ms. Laurie Lean, as well as Mr. Ruthven. Will you be sharing your time, or?
No, I'll make the remarks. Mark is here, just in case you have technical questions.
Yes. I have 2 of those.
Yeah.
Ms. Laureline, please
Thank
proceed.
you.
10 minutes.
Thank you for this opportunity to present the Mining Association of Canada's views on the Fisheries Act. MAC is the national organization representing the Canadian mining industry, comprising companies engaged in mineral exploration, mining, smelting, refining, and semi-fabrication. Our members account for the majority of Canada's production of base and precious metals, uranium, diamonds, metallurgical coal, and mined oil sands. I am accompanied today by Mark Ruthven, Associate Biologist and Assistant Group Head of AMIC Foster Wheeler. Mr. Ruthven is a member of the MAC Fisheries Act Task Force and has been deeply involved in our work with Fisheries and Oceans Canada officials to understand the 2012 amendments to the Act. He has direct experience with Section 35 review and authorization process. MAC had not advocated for legislative change to the Act, fearing the uncertainty and confusion that would be caused by departure from decades of jurisprudence and established practice. However, once the Act was amended, we worked with DFO officials to understand how to adjust and continue to comply with the Act. In the mining industry experience, the 2012 changes to the Fisheries Act have, in practice, broadened the circumstances in which the Section 35 prohibitions apply and increase the circumstances in which an authorization and offsets are required. While noting the increased burden on mining project proponents imposed by the amendments, we are not requesting that they be reversed. In our members' experience, the amendments have encouraged greater attention to sound science and the purposes of the Act. However, our experience underscores just how critical planning for and executing transition to amended legislation is to avoiding confusion and imposing unfair costs on companies. In the case of the 2012 amendments, there were significant challenges with the implementation and transition, and the department was not resourced sufficiently to assist project proponents. Training was not provided until well after the provisions came into force. This resulted in unacceptable delays and costs to some projects caught in the transition. Should your committee recommend any further amendments to the Act, we urge you to accompany them with recommendations for appropriate resourcing, training, and planning for future transitions, including having an implementation plan fully in place prior to coming into force of any amendments. Mining projects observed several problems in managing the transition to the amended Act when all the amendments came into force in late 2013. DFO did not provide timely or adequate explanatory guidance and training that will help proponents and DFO regional staff to interpret and implement the amended provisions. That explanatory guidance, such as how to identify commercial, aboriginal, or recreational fisheries and fish that support such fisheries, or how to assess fisheries productivity, still falls short of what is necessary for clear and consistent national application. As well, DFO reduced the number of its regional offices and staff at the same time as the amended provisions came into force, further reducing the assistance available to project proponents. Finally, DFO did not account for the impact of the amendments on projects that had already substantially completed studies and consultations recommended by DFO staff to prepare an application for authorization. Abruptly and without strategic use of a grandfather policy, proponents were advised that their application plans had to be modified to include more water bodies and to incorporate productivity and other new policy concepts without guidance on how those new concepts were to be operationalized. Despite the initial challenges observed by our members during the implementation of the amendments, some members report that application of the revised Act has begun to evolve into a consistent and predictable process. We believe that the amendments have encouraged improvements to the scientific rigor of fisheries protection measures of the Act, and specifically with administration of Section 35 reviews and authorizations. The increased enforcement provisions and regulations governing applications for authorizations has resulted in an applied movement towards better defined and scientifically defensible productivity metrics, as well as project success criteria and clear and defensible monitoring commitments. The integration of contingency measures and defined thresholds directly linked to monitoring provides additional controls, which ensures that impacts to Canadian fisheries are accurately identified, appropriately monitored, and successfully accounted for by offsetting measures. In light of MAC members' experience with the Fisheries Act, MAC recommends that the committee urge the government to improve and increase the department's compliance promotion capacity, including increased guidance and training. Should the committee choose to recommend amendments, they must be accompanied by transition provisions, and for any recommended amendments, the committee should also urge the government to have in place, before coming into force, adequate implementation and transition plans, departmental capacity, and compliance promotion. Thank you.
And thank you very much. Finally, for 10 minutes, we'll go to Ms. Hendricks from the World Wildlife Fund. Ms. Hendricks.
Thank you, Mr. Chair, and thank you to the committee for giving us the opportunity to contribute to your study. My name is Elizabeth Hendricks, and I'm the VP of Freshwater for WWF Canada. For half a century, WWF Canada has worked to protect nature. Our global mission is to stop degradation of the planet's natural environment and to build a future in which humans live in harmony with nature. We create solutions to the environmental challenges that matter most for Canadians. We work in places that are unique and ecologically important so that nature, wildlife, and people thrive together. Our recent Living Planet report revealed that worldwide freshwater wildlife populations have declined 81% over the past 4 decades. That's more than twice the population decline for land-based or ocean wildlife. Habitat loss is the #1 threat to that decline. In Canada, WWF's watershed reports also show us that habitat loss is one of the greatest threats to our watersheds. 8 of 19 watersheds in Canada have a high to very high threat of habitat loss, and 6 of 19 watersheds have moderate threat of habitat loss. We're here today because we're deeply concerned about the health of Canada's species, freshwater, and marine ecosystems, fisheries, and about the communities across the country who depend on them. The Fisheries Act is a critical piece of legislation, and I commend you on the important work you're doing as a committee to lead Canada through this review. As you heard from the Minister when he testified 2 weeks ago, without fish habitat, there will be no fisheries. And we know that healthy habitat and sustainable fisheries are needed to ensure community prosperity for so many Canadians. I also want to take a moment to express our support for the West Coast Environmental Law submission on the review of the Fisheries Act. We understand that their excellent comprehensive briefing was submitted to the committee last week and was mailed to each member. I'd like to deliver the remainder of our testimony today in two parts. First, on restoring lost habitat, and second, on the opportunity to modernize the Act to ensure our environmental legislation is fit for addressing the challenges of the 21st century. First, I will speak to restoring lost habitat protection provisions. Restoration of the habitat protection provisions is essential if Canada intends to take conservation of biodiversity seriously. Since coming into force in 1868, the Fisheries Act has been devoid of specific principles relating to biodiversity and sustainability. Prior to the 2012-2013 amendments, however, the Act did offer legal protections for our oceans, freshwater, and habitat, with Section 35 and 36 working together to prevent the destruction and pollution to Canada's bodies of water. The Fisheries Act was Canada's strongest environmental law, mainly because it prohibited HAD, the harmful alteration, disruption, or destruction of fish habitat. We need to reinstate HAD and reverse the narrowing from protecting fish habitat to just protecting fisheries. Protection for all native fish, and not just commercially viable fish, are required to ensure biodiversity is protected. An ecosystem approach to management requires this protection and not just fish that support an established fishery. In 2012, by repealing Section 32, the prohibition against the destruction of fish by means other than fishing, there exists a gap in the protection of fish. Along with the return to HAD, it is also necessary to restore Section 32, as it appeared in the Fisheries Act before the passing of Bill C-38. When Section 32 disappeared, examples of lost protection from lost protection from industrial activities. To modernize this act, the West Coast Environmental Law has recommended adding prohibitions for sublethal harm, and which we support. The WWF Canada understands that mitigating cumulative effects is vital to ensuring the health of fish habitat. And this is why we contributed to a cumulative effects assessment in BC as part of the Marine Plan Partnership for the North Pacific Coast. Prior to the 2012-13 amendments, the Fisheries Act worked in concert with Canada's environmental assessment legislation to ensure oversight for harmful activities resulting from industrial activity. This level of scrutiny must again be recaptured through strengthening of both the Fisheries Act and the Canadian Environmental Assessment Act to ensure that the cumulative effects of development and activities are understood, avoided, or where absolutely necessary, mitigated. Now I will speak to the opportunity of modernizing the Act. We have three core recommendations. One, unlike other important environmental acts, such as the Canadian Environmental Protection Act, the Fisheries Act has no preamble. By including a preamble, we can ensure fundamental guiding principles to the Act are included, such as, but not limited to, evidence-based decision-making, an ecosystem approach, precautionary principle, transparency and accountability, co-management, and incorporation of traditional knowledge. These principles would not only strengthen the Act, but bring it into line with progressive fisheries legislation of other countries, such as the U.S. Magnuson-Stevens Act, and Canada's other environmental legislation, like the Oceans Act, as well as with DFO's own sustainable fisheries framework and Canada's international obligations under the UN Fish Stocks Agreement and the Convention on Biological Diversity. Additionally, these principles are critical to the successful rebuilding of Canada's fisheries, including some of our most iconic fisheries like northern cod. Second recommendation is that these guiding principles need reinforcement by prescriptive provisions for fisheries management objectives, principles and procedures, and safeguards to remove the absolute discretionary power of the Minister of Fisheries and Oceans in fisheries management decision-making. For example, including quantitative definitions for overfishing and recovery, and mandating recovery plans, and rebuilding timelines for overfished and depleted stocks would go a long way to increase political accountability and transparency. Finally, a modernized Fisheries Act needs to ensure legal obligations for monitoring, open data, and transparency. We would like to see updating of the monitoring and reporting requirements of the Act. As the committee heard from Professor Olsinski's testimony, fish habitat monitoring has been inadequate for a number of years. In particular, we would like to see the monitoring and reporting requirements of the Act updated to include provisions for citizen monitoring and enforcement. Adequate resourcing must support these provisions so that a range of communities, Indigenous groups, and coastal communities can actively participate in monitoring. Increased powers for monitoring will also help with understanding of cumulative effects. For example, freshwater monitoring to demonstrate the state of the watershed reveal how effectively fish and fish habitat are being protected and can identify where improvements are needed. A framework that effectively communicates results in a report back to Canadians is vital for transparency. Of course, a baseline understanding is required, and currently that does not exist. Here I would direct the committee to WWF Canada's Watershed Report Health Assessments, which assess at a national scale the health of watersheds, and as a proxy, fish habitat to Canada's waters. It is through this tool that governments can regularly report back to Canadians on results and progress of fish and fish habitat protection. This framework, at the very least, is a tool to prioritize, but also provides DFO a tool as a solution towards better monitoring, communication, and transparency. So in summary, the Fisheries Act is a critical piece of legislation. WWF Canada recommends the return of HAD, protection for all native fish and not just commercially viable fish, reinstating Section 32, the prohibition against the destruction of fish by means other than fishing. And secondly, WWF recommendations for modern safeguards to ensure that the Fisheries Act is brought into the 21st century and is an effective cornerstone in Canada's environmental legislation, including sustainable principles, specifically an ecosystem approach, the precautionary principle, community-based management, to guide fishery management, decision-making, and cumulative effects, prescriptive guidance on fish management objectives, principles, and procedures, and better monitoring, open data, and transparency. These are just our top priority recommendations for you. We recognize the time is limited, and so we will be following up with a written brief for your consideration as well. And at this point, questions?
Thank you, Ms. Hendricks. And that's exactly where we're going, right to the questions. As we do this, just to point out to our witnesses that we go in several rounds, each taking a turn, 7-minute questions followed by 5, and then back to 7 again. Well, looks like we will have time at the end for a few quick questions. But to our witnesses, if you feel like you want to weigh in on a certain topic, I would suggest you raise your hand as such, but try to get the attention of the person asking the question, not me, because when I give 7 minutes to someone, that 7 minutes is of their own. So if you wish to weigh in on that, and that includes those watching through video conferencing, if you wish to weigh in on a subject, please raise your hand to our questioners. And again, to our questioners, my colleagues, keep in mind, try to keep your questions, try to mention who your question is towards, even if it's a general question to everybody. Please choose someone, because it's difficult for people who are video conferenced in for them to take part when you just open it up in general. So, that being said, we're going to go to the government side. Mr. Hardy, for 7 minutes, please.
Well, thank you, Mr. Chair, and thank you, everybody, for being here. First question will be to the independent fishers. Can you see a situation where supporting the fishing economy, as you describe it, and promoting habitat protection are linked?
Absolutely.
Okay. Can we have some
Absolutely. They're
details?
intimately linked. If we, and I believe my colleague Mr. Gahn addressed this, if we don't have a healthy ecosystem, we don't have healthy fisheries. We are extremely sensitive to that. We have a huge amount of knowledge about the ecosystem, details that actually aren't incorporated into our management system. Distinct spawning areas for instance, of different species, herring, ground fish, lobster, all these areas that can only come from knowledge on the ground that's accumulated over, in some cases, centuries. When we're talking about First Nations people, it's for time immemorial. But in Atlantic Canada, we have 400 or 500 years of occupying the territory, and we've accumulated that traditional knowledge. And we know, for instance, I can give you some examples. In the Miramichi, when the town was talking about putting a sewage outlet into a spawning area for striped bass. They didn't know that. Fishermen knew that. Right? There's all kinds of examples so we need these environmental protections. We need for a healthy coastal economy based on fisheries, and that's what our coastal economy is based on. Fisheries.
Well, being from the West Coast, of course, I'm thinking of all of the small fishing villages up and down the coast, and we get the suggestion from folks like yourself that the corporatization, if you want to use that term, of the fishing industry there has had a largely negative impact on the small community fishing fleets. And again, maybe this is a very softball question to you, but can you see a link between that and perhaps the inadequate monitoring of habitat?
Well, certainly we see a link between outside corporate fleets, if you want to put it that way, coming in and fishing in waters that they don't have that local knowledge on. They bring in their fleets from outside, and so that's what I referred to in my comments about the independent owner-operators being closely tied to the ecosystem. We've lived there. I mean, these are fishermen that have inherited their licenses from their great-great-grandfathers, going back as long as non-native people have lived on our shores. So nobody that is operating a corporate boat based out of Vancouver, for example, or Yarmouth or Halifax coming into our waters is going to have that kind of knowledge. So that is the link, is the people that have been fishing those waters for generations. They learned about these spawning grounds from their fathers, and we've done a great deal of independent science on identifying these and recording this traditional knowledge that the fishermen have.
Have you noticed, or have there been any specific examples where the lack of, if you like, the local eyes and ears in the water have resulted in habitat degradation?
Well, I can't point to any specific examples of that, but we do see what we non-traditional fishing practices by these corporate fleets. Like doubling in the effort on fish stocks is one of those things, because the traditional independent owner-operator fishermen fished their gear once a day and went home for supper. These corporate fleets come in and they fish around the clock. They double stack licenses and they fish around the clock, exponentially increasing the effort on those stocks that we're trying to manage, that we have managed sustainably for 130 years in the case of lobster fishing. And the evidence of how well it's been managed is right there in the catches that continue to rise record high levels ever since people started selling lobsters that they caught.
Ms. Hendricks, question for you. You mentioned that modernizing the Fisheries Act could maybe start to rely a little bit more on traditional knowledge, citizen science, etc. And in fact, the waterkeepers mentioned that same point. With respect to what we've just heard from the independent fishers, does that appear at first blush to be an avenue where we could actually strengthen that, that aspect of management?
I think definitely no longer can we afford as a nation to expect federal government to do everything across the country, and I think communities and First Nation have been eager to play a role in their territories and monitor and take responsibility for their land, and I think that support and promotion of local knowledge can only benefit.
Do I have any time left? 1 minute?
Tree.
To the water keepers, you've seen the changes come and the implementation take place. I guess the question is, have you any knowledge of anybody that's done anything currently that would have drawn sanctions under the old legislation?
It's a good question, and it's one I get, as I'm sure you do, often. I think one of the great examples we have of where local knowledge and discussion about fish and fish habitat wasn't taken into consideration in a project was something we worked on in Moncton, which was the Causeway. Back in 1968-69, when they went ahead with that, they didn't apply for a Fisheries Act permit to destroy fish habitat, nor a Navigable Waters Protection Act permit, so they didn't get any of the information from the local community about fisheries. It was about a decade later when the salmon fishery disappeared on the Petitcodiac River, and when we put together our case to support a new assessment at the project to see if they needed free flow in Moncton, I went out and collected evidence from all the old fishermen who are now in their 70s, because there wasn't a consolidated or aggregated area where this evidence was collected, who caught salmon, how often. So we collected that as affidavits. That was a great example of a project that, for 30, 40 years really did incredible damage to the 17 rivers upstream, to all the species of fish in that river, because it exempted itself from the type of environmental law that the Fisheries Act now requires, did require until 2012 and doesn't again. And so when I look to the future and I see how prosperous that community has become since it's opened the Causeway gates up, I think now of what's possible under the new Fisheries Act, where if you put up no fishing signs in your community, on your river, in your bay, in your harbor, the Fisheries Act no longer applies. The Habitat Protection Act no longer applies, because there isn't a significant commercial, recreational, or indigenous fishery. And so what sort of knowledge are we excluding? What sort of information are we missing out on? What sort of traditional ecological knowledge are we just ignoring? And it's hard for environmental groups like ours to prove the damages. But we know from experience they're happening. And I think it's going to be a real onus among all our groups to make sure that we truly do a better job of documenting those changes and bringing them forward to government, because I think unless we're able to carry that burden forward with the government, it's going to be very hard to answer questions like that of what are we losing and what damage is being caused.
Sorry, I have to leave it at that. We have to go to our next questioner. We're going to go to the opposition, Mr. Sopik.
Thank you. I want to thank Mr. Matson for pointing out how inadequate the old Fisheries Act was when he used an example from 35 years ago. Regarding the a number of the presenters talked about the lack of any habitat protection. On the contrary, under the new Fisheries Act, serious harm to fish is defined as the death of fish or this permanent alteration to or destruction of fish habitat, with fish habitat defined as spawning grounds and areas and so on and so on. So this idea that the new Fisheries Act has no habitat protection is completely without foundation. I should also make out the point that the Blake law firm, in an analysis of the new Fisheries Act, made the point that the federal government's constitutional authority to regulate impacts to fish and fish habitat flow from its powers under the Constitution Act 1867 over coastal and inland fisheries. Canadian courts have confirmed more than once that these powers are limited to fisheries as a resource and do not mean the federal government has the power to regulate over all fish or fish habitat in Canada. In this respect, the new prohibitions are to some extent a codification of that which already exists in law. I very much was interested in the testimony of the independent fish harvesters, and of all the presenters, they took the people first approach, which I think is the right approach. And our new Fisheries Act focused on fish productivity. My assumption, Mr. Allen, that your members and your communities are intensely interested in fish productivity. That's my question.
In the productivity of our fisheries, yes, very interested. Our members, for example, in 2009 entered into a a strategic partnership with 15 Canadian universities looking at the health and productivity of our ecosystem under a very interesting program that was put in place by the last government, where research monies were made available to different industries, to academics, provided they could come up with some research projects, collaborative research projects with their industry partners. And we were, as the owner-operator of Fisheries, very successful in engaging in a whole pile of research projects with these universities, looking at the question of productivity, because it is very important, and a healthy ecosystem is critical to productivity, fisheries productivity.
And that is why we had, as a policy under our government, the replacement of any lost productivity. And you can do that in many ways through various fish management projects. I'd like to now go to the Lake Ontario waterkeepers to follow up on a question from my colleague, Mr. Hardy. Can you give me a specific example of any serious harm to fish or fish habitats that happened as a result of the new Fisheries Act? And I'm not interested in answers related to consultation or studies or how many scientists. I want a specific example of specific harm to an actual fishery directly related to the changes that we made to the Fisheries Act.
Sure, and just to be clear, Mr. Vice Chair, the Moncton stuff occurred before the Fisheries Act, so it was afterwards, when the Fisheries Act was in place, that the meaning and force was given to it. And it is about people. And so one of the great examples is the nuclear power plants. They don't have closed cycle cooling. They have open cycle cooling. So they kill fish 24 hours a day, 7 days a week. And there was no permit given by DFO. As a result of the changes to the Fisheries Act, the CNSC is now able to give that permit, and gave such a permit last year. It turned what was illegal and something that was pushing the industry to move to closed cycle cooling, like all other nuclear power plants in North America and around the world have been moving to over the last 3 decades, to now making it legal. Our group was at those hearings. We argued against it. We gave that example before the changes were made to the Fisheries Act, and now what was illegal at all 3 major plants is now legal. So that's one great example. I can give you more.
Has a fishery been destroyed because of that? Can you name it?
Millions and millions and millions of fish are killed every year by those plants. And yes, the indigenous native fishery is fighting it up on Bruce, and here in Lake Ontario, where the fishery is destroyed already, but for a couple families down in Prince Edward County, there isn't a fisheries left that really is able to fight for it from a commercial point of view. So we, from a recreational point of view, because there's still a very strong recreational fishing in Lake Ontario, we're standing up for those fishermen and those people and trying to protect those fish.
Interesting that there's a strong recreational fishery in spite of the example you used. Regarding, I'd like to turn to Ms. Hendricks.
Why is that interesting, Vice Chair?
I'm the questioner here. I'd like to turn to Ms.
I was just wondering why that was interesting.
I was actually appalled, Ms. Hendricks, to your testimony when you so blithely dismissed fisheries. You called it just fisheries, as if the people who fish or depend on those fisheries really don't count. And I should make a point in your testimony, you were mistaken when you said this new Fisheries Act only applies to commercial fishing. It was specifically directed to Aboriginal, recreational, and commercial fisheries. So I would recommend you do your research. One thing I was quite shocked at in your testimony on page 3, when you said you want to remove and you want to have safeguards to remove the absolute discretionary power of the Minister of Fisheries and Oceans in fisheries management decision-making. Are you saying that fisheries management decisions should be decided by unelected officials, and fishermen and fishing communities should have no access or recourse to a decision that a fisheries agency may make? I would suspect that the fishing communities, and especially Mr. McDonald's constituency, would be very concerned if they had no recourse to deal with a decision that a fisheries agency had made and had no elected official to finally deal with. Are you really saying that the Minister of Fisheries and Oceans should be removed from fisheries management decision-making? Because that's what your testimony says. It's quite clear on page 3.
Well, now that you've made the most negative light on my testimony,
I just quoted to you your words.
I would suggest that having principles that guide decisions making and takes it out of political power. I'm not saying at all that we're removing the empowerment of communities to make comment. I am saying it shouldn't be at the political will that decisions are made.
Well, so again, to use an example, there's a shrimp quota allocation issue off the coast of Newfoundland right now, and what you're saying is that the fisheries minister should not be allowed to adjudicate who gets the shrimp, who gets the cod, and so on. I find that absolutely astonishing. To me, the decision-making principle that elected officials have the final say is absolutely sacred. How much time do I have, Mr. Chair?
I have 10 seconds.
10 seconds. The Mining Association, in your testimony, you made the point that that the new Fisheries Act has strengthened provisions, have in practice broadened the circumstances in which the Section 35 prohibitions apply. So what you're saying is that the changes we made to the Fisheries Act actually strengthened the provisions of the Fisheries Act to protect habitat. Do I read that correctly?
Very quickly.
That was the practice of our members' mining projects, that in practice they were asked to account for more water bodies.
Okay. Thank you, Mr. Sopuk. And now we go to Mr. Donnelly for 7 minutes, please.
Thank you, Mr. Chair, and thank you to all our witnesses for being here and for providing your important testimony on this important subject of amending the Fisheries Act, or hearing consultation about amending the Fisheries Act. I would like to start off with the Canadian Independent Fish Harvesters. You, I believe, made 5 recommendations, but you also talked about restoring Section 35. So one question that I'll ask everyone is, have you submitted your wording to the recommendations in writing to the committee?
Well, we have submitted our letter to the minister, to the committee, and we intend to follow up with a written submission both to the committee and to the department. We have learned that there is a separate consultation going on by the department, so we will be submitting our detailed recommendations to you in writing, yes.
That's great. I would encourage you to do that, because that is critical, that not just witnesses, but anyone that's proposing changes to the Fisheries Act through this process, make sure they send their recommendations in writing in both official languages to this committee. Because as you've alluded to, there is some confusion that folks may think that just submitting it to the website or to the ministry or to the minister's office is adequate. It must also come, it's really important that it comes to this committee. And also, Mr. Lan, if you can comment on, will the wording that you're suggesting of the restoring, because I think Mr. Gaughan recommended that the Section 35 be restored, and that the wording of essentially had be included. I would encourage you to put that in writing as well in your recommendation, the specific wording that you'd like to see.
Yes, we will. We will be providing very specific recommendations. But I have a question to you. Do we have to submit written submissions in both official languages to the committee, as part of your online consultation?
Just to let you know, Mr. Donnelly, I stopped the clock.
Okay.
Since there was seemingly there was a question put my way. No, that is not necessary. We can do the translation. The rule is straightforward in the sense of distribution amongst the committee has to be in both official languages, both English and French. Your submission to this committee, to our clerk, can be done in one language if you choose. We will do the translation. We'll distribute. I hope that answers your question. Okay. Meantime, back to the clock.
Right. So maybe I should have said either official languages. Make sure it's in there. One of them will. Certainly for us, we need it in both. In terms of, Mr. Gaughan, you mentioned, you talked about pesticide use of fish farms in Atlantic Canada, and I'm just wondering what you feel is the solution to dealing with that issue.
Well, we think the solution for dealing with that issue is for the government of Canada to require the people that are using those pesticides to find the solution. These are newcomers into the waters. They've developed an agriculture industry there, and if they're having a harmful effect on the environment and on the existing fisheries, they should be required to deal with it. That's what we see as the solution.
And a more specific question: would you support something like closed containment technology?
Yes, certainly. Of course, we would certainly support any practical solution. And closed pen contained systems are I think we'll all find out that that is the way of the future, and that the technology is being developed for that. But at the same time as that is happening, we have governments that are, provincial governments especially, that are busy handing out more of our oceans to the same systems that are currently in use.
Also, last question to the independent fishers. Are you hoping that changes to the Fisheries Act will address the issue of owner-operator fleet separation on both coasts? Because certainly in Atlantic Canada, it's a far different situation than the Pacific coast, where on the Atlantic side, we have owner-operator fleet separation. We don't have that in British Columbia. Do you want to comment on that?
We're asking for two things, and thank you for asking that question and clarifying. So we're asking that the general principles underlying the owner-operator and fleet separation policy be brought into regulations, and as I said, this was promised to us by the Government of Canada in 2004. And we're also asking for changes both to the Fisheries Act and the Fisheries regulations to make the ability, or to recognize the authority of the minister to pursue social and economic objectives very, very clear, both in the Act and in the regulations, and to link it to conditions of license. And that would then become enabling. Enabling legislation and regulations for the type of detailed protections that you need on a fishery-by-fishery basis, whether it's in BC or in Atlantic Canada, through our integrated fisheries management plans, IFMPs. That is something that could work. We're in the situation in BC, the situation is disastrous. It will require a made-in-BC solution. For that, we are asking for an independent review of fisheries licensing policy in BC, an independent panel that could make recommendations to the minister based on consultations with stakeholders in BC, and to make some recommendations on how to get out of the situation there. But to hear from the people in BC on that, because the system is not working. It's not delivering on Canada's objectives for social and economic development of our fishing communities.
Okay, I have 1 minute left, so I'll do two quick questions then to the lake keepers, Lake Ontario waterkeeper. You presented 9 recommendations, excellent recommendations. Thank you for submitting those. Are you also submitting those in writing to this committee?
Yes, Mr. Donnelly, we'll be submitting a written piece later along with other water keepers, river keepers, bay keepers in Canada. We'll try and do that jointly.
Thank you. And just in the remaining time, I just want to switch to the World Wildlife Fund to just if you want to comment, because I also was looking at, you have excellent recommendations put in here. We can review those. Thank you for submitting those. They're in both languages. And I just wanted to finish with asking about this removal of the absolute discretionary power from the minister. And other jurisdictions around the world, could you mention if there are others that do this?
I believe very good question, and thank you very much. I represent both oceans and fisheries, so I will get back to you because I would like to consult my oceans experts, but I believe the U.S. Act does restrain the political power over the Act. Thank you.
Okay. Thank you, Mr. Donnelly. Now we go back to the government for 7 minutes. We're going to Mr. Morrissey, I believe. Mr. Morrissey?
Thank you, Chair. I would direct my question to the independent harvesters. You made the comment that the review should be doing a holistic approach to reviewing the Act, just not focusing on the habitat side of it. Could you just elaborate a little on that, Mark?
Well, I mean, that's sort of the basis of our whole point, is that we believe our Fisheries Act and the Government in Canada, in terms of its approach to fisheries, should consider this as a resource, and that's what the courts have said, that the government and the minister has to see fisheries as a resource, that it conserves, manages, and develops in the public interest and for the benefit of Canadians. And that is pretty close to a sustainable development approach. And the Canadian government is committed to sustainable development. And that was a big breakthrough at the UNCED meeting, the Earth Summit in Rio in '92, when they said, okay, going down the road of just economic development, it makes sense. You have to have social development, and you have to protect the environment. So you need all three of those things. And that's why Romeo LeBlanc was way ahead of his time. He took a sustainable development approach before it was, a concept that was broadly made popular in Rio. And so that's what we need. We have an act right now that's just focused on conservation. And we know where this happened. It happened because of the cuts that were made to the fiscal crisis of the government in the mid-'90s, and you had to cut. And the Department of Fisheries and Oceans looked at that, and they said, okay, well, we're just going to focus on conservation. And que le diable m'emporte le reste, in terms of, fishing communities and the economy.
I have one clarification. You said that fishers have lost ground as the department has focused on different areas, and I think you're using that comment in relation to the owner-operator policy, where there's things going on there that are not being enforced by DFO. Am I correct in interpreting?
Absolutely. Absolutely. I mean, we've been working on this for 20 years. Saying, okay, we have these really good policies saying that fishing license go to the individual, and the individuals have to fish them themselves, and they have to live in coastal communities, and we need that for the social and economic development of our coastal communities. Well, it hasn't been working. People have been finding workarounds, right? And so we come up with all kinds of measures with the department, right, that are in the policy side of things. They're not in the regulations or the legislation. And they don't work. And I was talking to the person in the department responsible for this last week, and he said, well, we devised a Rube Goldberg machine to deal with this. And I didn't know what a Rube Goldberg machine was. But
what is it?
But it's a big contraption where you put something in here and it moves all these gears, and maybe, after a little while, you get a result here. Well, they had designed a Rube Goldberg machine for us for PIFCAF, and it doesn't work, right? So they announced new measures in September, right, for
last year.
This year, they were based on recommendations we made two years ago to the department, right, on tightening up the vacation provisions and the in-season stacking of licenses. Within hours of the department having announced that they were going to tighten up that, the violators of the owner-operator and fleet separation policy had a new workaround. And they got all their approvals through, right? So it's in this, because it's in policy, we have no recourse. It's in the soft, very, very, very soft law.
So you want to see it in the Act?
We want to see it in the Act. We want to see it in the fisheries regulations. We saw it in the conditions of license. But you bring it into the conditions of license, and then if you violate those conditions of license, you have committed a criminal offense.
Okay. How am I doing, Chair? He's not watching. That's okay. Any part of the Fishery Act changes that were made, is there any part of that should be kept? And I'll ask that to anybody that wants to respond to it, because looking at it, there was a process followed. Is any parts of those changes that you would, I want to start with the independent fishers, because you're the ones that get most affected.
I can say, Mr. Morrissey, that our members have not raised issues with us around things that they would like to keep from the changes. We have a lot of concerns of things that were done that are very, very problematic on the pesticides issue in terms of
that's
agriculture.
Interesting comment.
And there's, in terms of burden of proof, one of the things that people haven't talked about is that the DFO labs that did the toxicology research were closed down. So you can't do the research for that. We asked, through our partnerships with universities, to be able to rent the labs so we could do the research. We were refused. Brand new labs in St. Andrews that were designed for that purpose were closed down. And those are assets that are sitting empty right now. We can't provide the proof because we can't do the research, right? And we have to provide the proof. So there's a lot of serious damage that was done there, sir.
Okay. Do I still have time? Oh. I have a question to the water keepers. You were making the comment that all that is left is a recreational fishery, that the commercial fishery is pretty well all disappeared in Lake Ontario, if I'm quoting you correctly. Could you expand on that a bit for me?
Well, just factually, there are only a few families with nets down in Prince Edward County, Wolf Island, sort of where the river and the lake.
What kind of a catch would they be sustaining? The American eel was big. They're no longer in enough numbers to sustain a fishery. So there's still perch, walleye, pike, catfish, some carp. But on the American side, the fishery is completely closed, and for the rest of the Canadian side, it's closed as well, which is sort of a red flag when you think that the St. Lawrence Market in downtown Toronto was built to bring in the boats from Lake Ontario and sell the fish there for over a century, and now it sells no fish from Lake Ontario whatsoever. And I think our organization would love to see the Fisheries Act not only protect where we still have fisheries in Canada, but do something about restoring what we lost. Otherwise, those communities that are denuded in terms of fisheries and the environment really have little hope. And under the old Fisheries Act, certainly there was hope that that the Act would still be very aggressive in restoring fisheries in this country. And we hope that that gets put back into the legislation through our suggestions.
Thank you, Mr. Morrissey. We're now going to go to the opposition. Mr. Doherty, are you splitting your time?
I am, actually. Yep.
Oh, okay.
Thank you, Mr. Chair, and thank you to our guests as well, too. I do appreciate the differing views and the testimonies that we are hearing not only today but throughout the whole course of this. I'm first going to ask Ms. Hendricks. Ms. Hendricks, and I'm going to take a completely different, try at this here, but during the Northern Cod study that we did when we were over back east, we heard time and time again WWF's contribution or being at the table during with working with the fishers, working with the government. What's your role? What's WWF their role in the East Coast on working with developing policy and on that?
So we work with communities across Eastern Canada, bringing science-based, evidence-based decision-making to the table.
Okay. And so in lieu of DFO, so WWF
No, we
is there?
work across departments. I think it's a multi-stakeholder approach to solutions.
Okay. The other part that I wanted to ask you is in not only just your testimony, but others talked about seeing engaging communities, Indigenous groups, coastal communities, so that they can actively participate in the science, local science, using citizen science, I think was the word. During that study, the Northern Cod study, as well as our Atlantic salmon study that we had, we heard time and time again that, well, maybe not so much with the salmon, but with the Northern Cod. Well, the numbers are there. So the fishers just want to get out and get fishing. Mm-hmm. So is it your testimony today that we should rely on the local knowledge and the local science and then open up the Northern Cod study? I'm just using that as an example. That's what we're dealing with here when we have local knowledge and local science, and we've got the fishers that are saying, look, the numbers are back to where we've never seen them before.
Mm-hmm. I would say there's not one science that's better than the other. I think you need to bring all science to the table and have a discussion to make sure it's an evidence-based decision and that communities and government and all stakeholders are comfortable with decision-making.
Ms. Lourgine, during the course of the testimony from our other witnesses, I noticed that you were taking notes and listening intently, but I also noticed a few reactions to some of the testimony from our Lake Ontario witnesses, but others. And I'm wondering if maybe you can provide some insight as to your reaction to some of the things that you're hearing.
Oh dear. I have a very mobile face. I will comment. One of the things that puzzled me about the waterkeeper's testimony is the ascribing of the Section 36 regulations to the 2012 changes. They have been in existence for quite some time. The predecessor to the metal mining effluent regulations date back to the 70s. I believe the pulp and paper effluent regs. Some of the other ones, they're all date back to the 70s. That section there was very little change to it made in 2012. So I was just very surprised by that. The other part is the surprise in that our experience, and Mr. Ruthven may expand on it some more, our experience in interpretation of the changes has been very different. And we did not experience the narrowing, and we're not sure why our experience was that different, but we did put in the effort to work with DFO to understand what the amended act said.
Thank you. 1 minute?
Okay.
Oh, sorry.
1 minute?
Go ahead.
Oh. Sorry. Yeah, just a couple, if I can fit them in quickly. Ms. Hendricks, can you tell us how much in foreign funds comes into WWF, into Canada, and how many funds are spent in Canada? I want to know the ratio of how many foreign funds are being imported into your operations in Canada versus what we actually spend here.
Actually, very little. WWF Canada is part of an international network, but WWF Canada's programming is within Canada. The majority, the freshwater program is all Canadian funding. Their other programs are majority Canadian funds.
Okay, thank you. Mr. Matson, you referred to the power projects that is killing fish, and you stated that what was illegal has now been made legal, but could it not also be made illegal? And is it not the case that someone has done an assessment here, determined that the impact is manageable, and has made that operation legal?
Thank you, and thank you for the question, because I think it cuts to the whole heart of what we're talking about. Under the old Act, killing fish, depositing a deleterious in waters frequented by fish, or destroying a fish habitat was illegal unless the proponent could prove that it wouldn't have an impact on fisheries, etc. They couldn't do that. That's why they never had there was lots of opportunity to apply for those permits at the time. It's only since the changes to the Act, now the industry looks at the fisheries in Lake Ontario, sees it's depleted, sees that there is no commercial fishery, and says there isn't a value in changing closed cycle cooling or open cycle cooling to closed cycle, and now has permitted themselves to kill the fish 24 hours a day, 7 days a week. Now, they have put nets out front to stop the big fish from dying. But
sorry, Mr. Arnold, I have to cut you off right there. You're well over 5 minutes at this point in response. You can get a chance to do it later. We've got quite a bit of time left, so we'll circle back to get back to you later. Ms. Jordan.
Thank you, Mr. Chair, please. And I'd like to thank the witnesses for appearing today. I think this has been extremely interesting testimony. I guess my first question, actually, I'm going to go to Mr. Matson, because I would really like to have his response to the comments that were made earlier by Ms. Arlene.
Yes. The 2012 changes made it possible to make new regulations that exempt industries, specific industries, under Section 36.3. So those regulations have come into force since then, particularly wastewater effluent regulations, sewage treatment plants. That's why there's a lot of confusion around whether Montreal was able to release sewage into the St. Lawrence or not, and whose responsibility it was. Also under nuclear power. And there are others who are able to apply for those exemptions. So the changes were made in 2012 to allow for specific industries to apply under the regulation to make for exemptions for their industry, and they've been taking advantage of that. And secondly, it's changed who has the authority to do it. For example, now the provinces can apply for it's called a equivalency agreement, where if they have laws that deal with the same subject matter as the Fisheries Act no longer applies. And that's why we say there is no longer a Canadian law that applies in all provinces licenses across the entire country, because as a result of the changes, they've downloaded that onto the province, and each province has its own ideas about what it wants to protect and where it wants to put its priorities.
Thank you. I'm actually going to go now to Mr. Guan, and you have been a fisherman for 40 years. Do you still fish?
I do. I've been a fisherman for 41 years, and I still fish, yeah.
And I guess my question to you then is, you've seen a lot of changes over the last 40 years. I grew up in a fishing community on the South Shore. I've seen it from, watching the last boats go to Lunenburg, so I know what it was like. Can you tell me what you see enforcement like now compared to over the years? How has enforcement changed in terms of DFO, and what's?
Well, it's certainly there's increased enforcement today than there was 40 years ago, but of course there's also increased things to enforce. We still have shortfalls in enforcement in a lot of areas. And just in the last year, we have seen a stepping up of enforcement efforts in our area, with multiple prosecutions for illegal fishing in my particular part of the world. And that's a good sign, but it's been a long time coming, and there's lots more room for improvement.
Where do you see the shortfalls?
What we got at earlier was the enforcement of the fisheries licensing policy, which over time has slipped, not increased. The actual enforcement of the fishing regulations on the ground, we're starting to see a little bit of improvement now, but there's much more to enforce as well. So,
where do you see the shortfalls in enforcement?
Well, the biggest shortfall we see is in the failure to enforce these licensing policies that are supposed to protect people, and that's a one-way street. When those protections are lost, it's very difficult to get them back. When owner-operator licenses are allowed to be sold to corporate interests who are not owner-operators, then how do we get them back? And those are a heritage of our coastal communities for hundreds of years, and that's our raison d'etre for our communities. You know it as well as I do because you come from there, and people in BC and the coastal communities have the same situation. We're looking at something that could lead to what's happened in BC, which is a disaster, and we're going to fight to the very last day to preserve the nature of our coastal communities in Atlantic Canada. And the fact that their policies, not law, allows officials, not the government of Canada, but officials in the regions to bend and twist those policies to allow things that happen that aren't supposed to happen under those policies.
Do I have 1 minute? Okay, I'm going to actually go to Ms. Hendricks. You had mentioned reinstating sections 32 and 35 in the Fisheries Act, but you also said that the Fisheries Act needs to come into the 21st century. Do you think that there's provisions that have that the changes were made in the last government that should be kept? Do you think that we just automatically reinstate what we have, or should we expand it? I guess is how I'm.
Thank you very much for the question. I do believe there's some reinstatement, but I think there is an opportunity to modernize. So in 3 ways, I would suggest monitoring, ensuring monitoring, open data, and transparency, prescriptive guidances, and then our last one was specifically around the preamble, ensuring sustainable principles, and a guiding, let's say, a guiding light for the Act.
That's it.
Good.
Sorry.
Thank you.
Mr. Sopek, 5 minutes, please.
Interesting, Mr. Allen, that you mentioned the Earth Summit in Rio. I'm showing my age, but I was a delegate at the Earth Summit in Rio, and it was quite the experience. And I agree with your views that the role of the concept of sustainable development, which I strongly believe in, came really out of the fore. Regarding Lake Ontario and the commercial fishing, the waterkeeper's testimony, I would submit that it's because of fisheries allocation that there's little commercial fishing, because I know from personal experience that the sport fishery on Lake Ontario, across much of it, is thriving. But regarding the testimony of Mr. Matson regarding the millions and millions of fish that are being killed by this nuclear warm water outflow, why hasn't there been any media? Why haven't there been any pictures of these millions of dead fish? Even under the new Fisheries Act, that can be stopped. I mean, you're not allowed to kill fish in that regard. Why hasn't more been made of that? Where are the pictures of these millions of dead fish?
Well, both good questions. I mean, we participate in all the CNSC hearings. We've brought in evidence. We spent thousands of hours trying to bring this to the attention of the public, and it's all on the record. It's admitted by the industry. They've done their own cost-benefit analysis, and they've indicated that the fish that they're destroying don't have much commercial value. There's no commercial value on the lake. So it's not under the new Fisheries Act. It really wouldn't require them to spend a lot of money to prevent them from killing it. And I think on the other point that you make is, it is a great lake. It's one of the 10 greatest freshwater lakes in the world, and yes, there's still a sports fishery, but the commercial fishery is gone, and that's a fact. And you can look back at the numbers and the nets and when it disappeared, but it's not something to argue about. It's something really to try and fix. I think to put our mind towards doing something about restoring this great freshwater paradise's lake. And if we do that for Lake Ontario, I think there's a real hope that we can prevent so much other damage across this country.
I should note as well that the Ontario Federation of Anglers and Hunters has been doing great work on restoring Atlantic salmon on Lake Ontario. Mr. Matson, again, talking about deleterious substances. A number of years ago, there were some extremely heavy rains in Prince Edward Island, and there was a pile of potato field runoff into streams. There were thousands of fish killed inadvertently, obviously, but it happened. There were deleterious substances deposited in those waters. Should those farmers have been charged or perhaps thrown in jail?
Well, I don't know about being thrown in jail. I mean, the courts are pretty open and they hear the evidence and what happened. Well, you know what? I don't know the facts of the case, but certainly under the old Fisheries Act, if there was a point source and somebody should have been, through due diligence, prepared to not allow that go into the river and expected that there would be fisheries death, then the way it is currently is that it's upon those who caused the damage to prove that they took all reasonable action and all reasonable steps to prevent it. If they didn't, it can go to sentencing, and we've seen sentencing of $1, but currently the act is, I think, up to $1 million a day and 6 months in jail.
Of course, I'm surprised that you don't realize that any runoff from agricultural areas that's non-point source pollution is clearly not point source. Regarding the old
that's why you need land use planning. That's why you need proper land use planning, and you need to work hard to ensure that what you're putting on the field doesn't run off. That's exactly what the Fisheries Act's intended to fix. It was under the old Act.
You tell the potato industry and PEI that is a very important part of that economy. That those of us on this side protect the agriculture. Regarding, I'd like to talk to my question to Mac, Ms. Laurie Jean. Under the old Fisheries Act, in testimony when we were going through the act from Mr. Kevin Stringer, he talked about they were having 12,500 referrals per year under the old Fisheries Act, and he was implying they were clearly swamped because every little dock and every little small walkway was considered a referral under the Fisheries Act, and they were completely swamped. Do you think they would have been able to deal with 12,500 referrals a year in, year out?
I don't know. That would not be something we would be familiar with as their internal operations. Yeah,
it's just that when we asked that, the Fisheries Act was interpreted at the time to mean every single little activity near or close to a water body, and that's how we ended up with an unmanageable setup. Going back to Mr. Matson, you were kind of scathing about provincial jurisdiction and provinces taking a role in fisheries conservation. I'm from Manitoba, and I clearly don't want somebody from across the country to have a say in how fisheries in Manitoba are allocated. Don't you think that fisheries management, the provinces should have the final say in how fisheries in their jurisdictions are managed?
Well, let me be very clear, sir. This is about Canadians and people, and this is a quasi-criminal statute that protects every Canadian. There is nobody who should be ignored just because there's so many people having deleterious substance put into their water, or destroying their swimmable water, or destroying fish habitat. You shouldn't claim there's too much red tape to deal with those people's voices. It's very important that this quasi-criminal statute, protect every Canadian, whether they're in Manitoba, Ontario, or BC, and no province should be able to put forward its own exemption such that it would take away the right to fishable waters. This legislation was put in place in the early 70s as a result of many, many damages that went on in the 50s and 60s. We learned from it. The federal head of power is criminal and fisheries. They joined the two together to create Section 35 and 36. It's not the time in 2016 to undermine that with arguments about jurisdiction. This act protects every Canadian and gives everyone the right to clean fisheries, and there is no fishery, no matter how small the pond or how big the ocean, that is exempt from this act, and I wouldn't want it to be so.
A clear case of winning the argument by definition if I've ever seen it.
Okay. Sorry, as entertaining as that may have been, I have to cut it there. I'm going to go to Mr. Finnegan now, and sir, you have 5 minutes. Please proceed.
Thank you, Mr. Chair. Je vais demander cette question-là en français, si c'est, je vais laisser les gens mettre leurs choses. Monsieur Alain, en Atlantique Canada, puis chez nous particulièrement, dans ma circonscription, les pêcheurs indépendants, d'après moi, ça marche assez bien, ça a l'air assez bien. On dirait qu'ils ont tous, chacun leur bateau, puis tout va. Est-ce que vous pouvez me montrer un exemple spécifique où...
Can you give me a specific example of how the policy might not be working and what we could do to address it? Mr. Finnegan, that's a very good question. Yes, the fishery is going well in maritime Canada. And this, thanks to the crustacean resources, especially lobsters. The amount of lobster has doubled over the past 10 years, and the price has gone up. So this is to the advantage of everyone. But it's not equal in its application. I think that fishermen observe, when you talk to them, that their catch may have gone up 30, 40%, even doubled. But in other areas, it's gone up even more. And that's where the problem is. Our most lucrative fisheries are in areas that various companies, not only Canadian companies, but foreign companies are buying lobster fishing authorizations. And all areas of the fisheries in Nova Scotia, some of them are buying up to 50% of the permits. So this is what we want to target. This is where we want control agreements, because these are permits that are supposed to be reserved for individuals. So they're using secret agreements to benefit from permits. So this happens in the southwest of Nova Scotia, in Bay of Fundy, and elsewhere. Now, we can't say, we could say to the department, go there. We know where the problem is happening. We know who the people are. We know what businesses are concerned. But now it's come to the point where it's criminal action, because there's a kind of Rube Goldberg operation. Because when we have an agreement, and now all fishermen have to sign an authorization, when they do so, they are committing a crime. But the situation isn't the same everywhere. Even where you're from, there are people, investors, who are buying lobster fishing permits. It's happening elsewhere. It's happening where you're from. We have to eliminate this problem before it gets worse, because what's happening where he is happening where you're from.
Does to many species of fish and our environment. are you opposed to all aquaculture if we're talking about the oyster industry and that? Do you have any issues with some of the other forms of aquaculture?
As I said in my comments, all of these projects we're not opposing. We're just demanding proper oversight and environmental assessments and responsible ways of carrying out these projects, whether it's oil or gas or aquaculture or any kind of aquaculture. What's happening in our oceans, first and foremost, we have to protect the wild fisheries. The numbers of jobs and revenue coming into our economy from that for the last hundreds and hundreds of years cannot be risked for some pie-in-the-sky scheme that may damage that. So we're not opposing these projects. We're opposing the fact that they're allowed to write their own rules when it comes to the terms of the environment and the habitat of fish.
Thank you. Maybe going back to Ms. Hendricks with the World Wildlife Fund, there was a question asked, and I think you never had a chance to answer. So there was an assertion made that WWF doesn't want the minister to make a management decision. Could you elaborate and clarify your organization's position on that view?
Sure. I think at this point there needs to be some constraints around ministerial powers. I think evidence-based decision-making shouldn't be swayed by politics, and there are ways to ensure within the Act that we are bringing the best science to the table to make decisions across the country.
Thank you.
Merci.
Merci.
Thank you. Thank you. Pardon-moi. Now we're going to go to Mr. Donnelly for 3 minutes, please.
Okay, thanks, Mr. Chair, and I have 3 minutes, so not a lot of time, but I do want to ask, I think we'll have another round and some more time, but so I want to ask a number of witnesses, ask all of you to submit your recommendations to the committee so that the committee captures all of what you have to offer in terms of the way of changes to the Fisheries Act and what is being consulted on here. But if you had to ask you or provide your top priority, what would your top priority be of all the recommendations that you've given? And I'm going to start with the independent fisherman.
Has to be Solomon.
Remember, I have 3 minutes.
We would take a sustainable development and holistic approach, and so we would say you got to protect the social and economic development and coastal communities by also protecting the environment in which their economy rests.
Thank you, and I'll go to the Lake Ontario Waterkeeper. Your top priority.
Thank you, and a great question. Our top priority would be to protect habitat by switching the onus back onto the proponent to show how and what they're going to do in terms of protecting fish and fish habitat, instead of what it currently is now, where it's switched it back to the public to show why they shouldn't get the permit.
Great, thank you. And WWF? Finish with.
I think we would go with the preamble, making sure we have guiding principles to ensure all decisions in the Act follow suit within those guiding principles.
Great, thank you. And Mining Association of Canada.
Capacity and guidance. You can write the most beautiful legislation in the world, and if the department does not have the capacity to deliver it, it's not going to be delivered.
Great, thank you very much. I'm sure I'm pretty close, or...
Well, you have a minute.
I have a whole minute. Well, fantastic. Look at how cooperative the witnesses can be. I will only ask a question that I'm going to run out of time for, but it'll be the preamble to perhaps a longer amount of time, and that's on how the Fisheries Act can be improved to talk or deal with the cumulative impacts. So that's, I'll probably ask waterkeepers to start in WWF and open it up to others that want to provide comment, but I'm sure perhaps waterkeepers could start off until the gavel comes down.
It's a really great question as well. The old Section 36.3 and the way it's currently worded still, if the exceptions weren't given, was to prevent the deposit of a deleterious substance into waters frequented by fish. It did prevent cumulative impacts because it didn't allow the proponent to sample from the receiving waters. It had to sample from the actual discharging waters, and so the idea was that the precautionary principle was built into it, and as long as no one put deleterious substance, those that kill fish, and 96-hour acute lethality test or whatever else you want to use, Daphnia magna, if you didn't put water that was acutely toxic, then there wouldn't be a cumulative impact problem. So now, with the new changes to the Act, the government's going to have to find new ways to take into account cumulative impacts, how it's going to measure it, how it's going to monitor it. And with self-regulation, it's going to be even harder because the government somehow needs to be in charge to keep an eye on what's happening generally, aggregating that information, and ensuring that the laws are put in place to prevent real destruction of fish and fish habitat, because we shouldn't wait until that happens before we act.
Okay, thank you very much. I'm going to have to cut it there. But we do have time, as Mr. Donnelly pointed out, for a round of 7 minutes each, as has been our custom. Each party will get 7 minutes to end this off. However, given the math, we will be approximately 3 or 4 minutes overtime. Can I have the consent from the entire committee that we can go overtime for by about 3 or 4 minutes? Is that okay? No objections? Okay, so let's start with Mr. McDonald for 7 minutes, please.
Thank you, Mr. Chair. And I've just got a couple of questions, so I'll share my time with Mr. Finnegan. You can let me, I'll know when I'm done anyway. There you go. First questions would be to Ms. Hendricks. Basically, in your opinion, should rebuilding plans for depleted fish stocks be legally required by the Fisheries Act, and why?
Yes, and I will flesh this out in our final submission. Yes, because, sorry, can you just repeat the question, because I want to make sure I'm answering it. Plans for depleted?
No, should rebuilding plans for depleted fish stocks be part of the Fisheries Act, and why?
Yes, because I think that's the role of mitigation and trying to address what has been lost, which should be a cornerstone of the Fisheries Act.
Okay. And how should requirements for stock rebuilding plans be incorporated into an amended act?
Again, repeat it just to make sure.
How should requirements for stock rebuilding plans be incorporated into an amended act?
I'm going to give you a half answer because I want to make sure I consult the oceans experts, but I would say, again, back to those principles, if we have guiding principles within our act, that would be half the answer, right? So sustainability, precautionary principle, how are we including those into any recovery plans? And then the specifics, I believe, would have to be in consultation with local, Canada's large, every fishery is slightly different. You'd want to make sure you're consulting a broad range of stakeholders.
Thank you. My next question would be for Mr. Gon, I guess, or Mr. Elaine. And being from the East Coast, of course, as far east as you can get, we keep hearing, and people even around this table will hint at the fact that we have an owner-operator policy that works, but I believe it doesn't. The West Coast MPs will say, like, we want what the East Coast, what Newfoundland has, or Nova Scotia, whatever, and it doesn't. Why is it not working? Because I know of instances where licenses are held by the fish plant or by major corporations or someone who sits in a condo in Florida. So why is it not working, and what have we got to absolutely do to fix it?
Well, I'll answer that. Clearly, it's not working because the policy that prohibits those corporations from owning those licenses has not been enforced. And that's why we're asking for those to be enshrined into law or regulation, because these policies came out, they worked for a little while, and you'll find out, the areas that don't have this problem yet, as they start making more money in the fishery, that's these corporations will be targeting every place where there's money. It's about money and it's about control. So the owner-operator fisheries have worked exceedingly well for generations. That's been the traditional way. That's why fishermen are so in tune with their environment, because they're owner-operators. They've handed it down through generations. And that's what's missing, is the ability for officials, not the government of Canada, not this committee, not the Minister of Fisheries, officials in the regions are able to bend those policies, and that's what they've done in every case of these corporate interests, being able to control. And it's fleet separation and owner-operator only protects one sector. The offshore sectors have already gone privatized. Foreign companies own them today. Mink farmers own part of the herring allocation in our area. A Scottish company owns part of the herring allocation in our area. We're only talking about the inshore sector here that's protected under fleet separation and owner-operator. And that inshore sector is the lifeblood of hundreds and hundreds of communities along the coast of the Maritimes and Newfoundland. And so that's why it's important that these policies become regulation.
Mr. Lane, you wanted to...
Yes, I mean, they could work. And that's what we're proposing, a way to make them work. We think that could work by bringing these principles into the regs and making them conditions of license, because then they become legally binding. And presently they aren't. People can look the other way, and it leaves us at a disadvantage, because we have to go through administrative ways to try to deal with the problem as opposed to legal ways.
Difficult. Mr. Finnegan.
Thank you. So before the changes to the Act, there was, in the old Act, I guess, there was prohibition against destroying fish by any means other than fishing, and or carrying on any work undertaking that results harmful alteration, disruption, or destruction of fish habitat, or HAD for a short acronym. So does the new concept of serious harm, would you say that adheres to the precautionary approach in managing the our fish habitat? Now, I'll leave that open to anyone that would like to talk about it. No one?
Want to
take it?
okay,
Mr.
Mr. Mattson.
Well, thank you. It's a great question. And by saying that, changing it to serious harm, that's my point, is it's putting the onus on the public to prove serious harm. What does that mean? They don't have access to the information. They don't have the money in order to actually be there and fight a lot of these causes, or do the research necessary to on the balance of probabilities to prove these things. But the proponent does, and it's the proponent who needs to have the onus to show that they're not going to conduct serious harm, and if they do, they need to show how they're going to limit it and what they're going to do as to replace it. That was the way the old Act was structured. Now allowing them to go ahead and destroy fish and fish habitat unless serious harm can be proven by I'm not sure who. It's not clear from the law now, and it's a very, very troubling situation that I think is unworkable, and it's why I list it as the #1 thing that needs to be changed as a result of the changes from 2012.
Thank you, Mr. Finnegan. Thank you, Mr. Mattson. Now we go to Mr. Doherty for 7 minutes, please.
Thank you, and again, thank you to our guests today. I find the testimony very interesting. Ms. Hendricks, and to Mr. Madsen as well, too, it must have been fairly frustrating for you, given your both organizations, or I guess more WWF's close relationship with our Liberal government previously and today, that within 20 days of being in government, the release of the 8 billion liters of raw sewage into the Montreal area. And I'm wondering, when our government took a strong stand and did not allow that and asked for them to reconsider their plans, I'm wondering how frustrating that must have been for you, and if indeed you took a stand on that. And I'm trying to see if there was any where your stance was at, but I don't see it. I'm wondering if you were fairly vocal on that. And were you blaming the previous government with that because we took a strong stance?
You want to go ahead?
So yes, just to clarify, Mark and I actually did co-author an article that ran nationally in the Globe and Mail. So we were very vocal about our concerns related to the Montreal sewage issue, and I'll let Mark speak to that in a moment. We don't want to comment on partisan politics or which party is responsible for what, but in terms of a chronology, it was the changes made in 2012 that created the conditions for all of the confusion surrounding what happened in Montreal. More recently.
Ms. Tully, but it was also our government that actually put a stop to that and told them not to release that. It was only after Mr. Trudeau coming into power that was released. Is that not correct? Is that not correct?
I can't speak to which party made which decision. Sorry.
I'm sorry, but the release, you would agree with me, but the release was after the Liberal government came into power, correct?
I'm not sure, but if that's factually correct, that's correct.
November 20th, I believe it was. Thank you. That's great. Ms. Hendricks.
Okay.
Ms. Hendricks, could you comment on that? Would that be...
So comment on WWF's relation to government?
Just how frustrating it must have been when you saw that, given your strong advocation, and again, you're here today talking about protection and the environment, and then you have a government that is newly in place, and they work collaboratively, and all of a sudden they're okaying a release of 8 billion liters of sewage.
So WWF did put out a statement saying that we, of course, were disappointed on the release of sewage into the St. Lawrence River. Yeah.
So would you say that again was that's something that's fairly frustrating, obviously?
Yes, that's why we're presenting for the Fisheries Act.
Ms. Hendricks, I find your information that you've provided is very good. I think a lot of the stuff that you're saying is okay. I'd ask that we've heard time and again that the witnesses have expressed an interest in DFO focusing not only on protecting fish habitat, preventing harm, but also rehabilitating habitats and fish stocks that have been negatively impacted. We see that a lot in terms of forestry practices, that if you are going in and cutting down trees, part of your forestry practice is that you're also replanting as well. Is that something that you think the next, I guess the next version of the Fisheries Act should include in terms of rehab and making sure that the replenishment is there as well too?
First of all, thank you. I am an expert and was invited by this committee as an expert witness, so my testimony is from an expert perspective. And in terms of rehabilitating habitat, yes, there is legislation around that Fisheries Act should be around protecting fish habitat. Yes, it's true.
And also on replenishing the fish stocks, obviously, and rebuilding fish habitat and building that as well too. Mm-hmm. How far should we expect that the fisheries or the Act go to replace those fish stocks?
That's a very good question. I think I can't speak to local fishery. I think it needs, as I've said before, it needs to be consulted and planned out and thought out, and science has to be brought to the table to ensure we're making decisions that are best for the community.
Okay. Thank you. I'll pass it over to Mr. Arnold.
2 minutes, so I'm sure that you're not all going to have a chance to answer this, but I would hope that maybe you could include it in a submission to us as a committee. We've heard time and again where we need measurables and goals, accountability, and so on. And I think that if we're to do anything with this Fisheries Act review, that's one area that I would really like to see, is that we set some goals, that we have some measurables, and we have some accountability afterwards. So far, we haven't seen that. And again, to what Mr. Doherty just mentioned here, when we looked at the Atlantic salmon, the question was asked, how far are we going to restore the fish stocks? And I asked the question, are we going to restore it to a level of commercial viability? And there didn't seem to be any appetite for that from the other side. but we heard testimony today that we should be restoring the Lake Ontario commercial fishery. So where do we find that balance within the Act? Those are the types of things I would really like to see put forward to the committee so that we can have some accountability, some measurables down the road so we know what we've done has been correct. If anybody has a 10-second answer, I'd love to hear it.
Go ahead.
Just from, my organization, we believe Canada's waters should be swimmable, drinkable, fishable. That's our vision. We're building a network of people around working towards that very goal. So in terms of the Fisheries Act, we'd like to see the Fisheries Act be very strong in its commitment to restoring fisheries for every single Canadian across this country. That's the goal, that's the vision, and certainly this is the only piece of legislation that the federal government has at its disposal to help us achieve that vision. So, yeah, we hold a lot of hope and put a lot of expectations into this act and hope it can help us get there.
We're just about out of time, but Ms. Hendricks, would you like to respond very briefly?
Very briefly. So I would say I hope, and I put my faith in this committee, that you put the Fisheries Act in a place that ensures we don't have collapses of fisheries like we have in the past. And so
Thank you. Mr. Donnelly, for 7 minutes to conclude, please.
Thank you, Mr. Chair. And I have a few questions. I'll come back to the cumulative impacts, but I wanted to raise an issue. We received a letter from the Lower Fraser Fisheries Alliance dated November 3rd. It was addressed to the Minister and to you, Mr. Chair. And I was CC'd on this. And they have brought up the issue of feeling that there isn't enough time for adequate consultation with their members. And so they represent First Nations from Hope to Vancouver, so in an area along the Fraser River, which is one of the greatest salmon rivers on the planet. And there's a number of bands there. So there are nations, and their concern is that they don't feel that with the deadline of being the end of November to provide the adequate consultation from all of the different nations along the river, that there's enough time to organize a response on such an important topic. So I hope that the committee will respond to this letter, will look at it. They actually suggest lengthening moving the deadline to the end of March of 2017, and certainly I brought up that concern that I know I received numerous requests from witnesses right across the country to be part of this process. So I hope that yourself, Mr. Chair, and the committee will respond to their frustration and their concern. I also have a concern that we have 4 witnesses at this committee, and I was hoping to take advantage of, because we have so few committee meetings to hear from witnesses, that we maximize the number of witnesses that we can hear from. Today we're hearing from 4. I think we probably would have had time for 6. That's certainly a concern that I'd like to address going forward, that we take advantage of the short time that or that this committee has chosen that we have to adequately hear from as many Canadians and organizations across the country as possible. So returning back to the issue of how to improve the Act in terms of the cumulative impacts, I just want to go to the Lake Ontario waterkeepers to perhaps finish where they were at. If you're already finished, I could move on to WWF and hear their comments.
Thank you, Mr. Doherty. I don't think we have much else to add. I think that our point is twofold, is that under the current Act with the changes, there isn't a lot. There aren't a lot of tools that we have in the Fisheries Act to look at cumulative impacts, and that the one tool we did have under Section 36.3, the test for a deleterious substance, has been, through the regulations, has been changed such that it can be exempted at the provincial level, or industry can exempt itself from. So I think it's a really great point to focus on cumulative impacts, because that's where the real damage will occur.
Thank you. And Ms. Hendricks, did you want to provide some comment on how the Act might be improved to deal with?
Yeah, I think I would point to the lack of monitoring and the importance of monitoring and transparency and understanding where the measuring stick is, and in each watershed, how do we understand holistically the impacts on the watershed, and how can we look back and understand impact over time, and having tools to be able to do that. There are solutions out there, and the government, I hope, and encouraged by this committee to explore solutions that are out there to promote watershed, a holistic look at the watershed.
And just in the remaining time I have, just to the independent fish harvesters, Mr. McDonald brought up a good point and said that even on the Atlantic coast, there seems to be, he feels the owner-operator fleet separation policy may not be working as well as he would like. And I think certainly if you look on the West Coast, we're not even close to that. We have ITQ, so we have individual transfer quotas, and the issue in the past has been essentially the concentration of power and accumulation of licenses, i.e. fish, and access to fish, and in other words, excluding other fishermen from fishing. And that's a real problem we're seeing more. I know I've heard loud and clear about the issue about slipper skippers, those that have little to no interest in the fishery, really perhaps just their financial benefit. So we're talking about a philosophy of how do we allow, what I heard clearly was, fish are part of the commons. They belong to the people of Canada, and they want access, and that's what I think we're discussing, is who should get access. And maybe in the remaining seconds, if Mr. Alain, you could comment on that.
Yes, well, I think our point is that the government of Canada has more than conservation objectives for its fisheries. Fisheries is this resource. It's adjacent to communities that have the capacity to go out there and harvest that for a broad social and economic benefit for those communities, and they need public policy instruments to ensure that happens. And by focusing exclusively on conservation and ignoring these other aspects, the government of Canada is not able to deliver on its broad suite of objectives. And it took us a long while to go down that road of ITQs, but it doesn't serve the purpose. It doesn't give the results in terms of objectives, the broad suite of objectives that a government has. And we have a situation in Scotland where they just recently, in the last 2 years, they regained control over their fish resources. And the first thing that they asked is they had a review of their fisheries policy, and because they found that access to the resource, the adjacent resources, was in non-Scottish hands. It was in corporations that were elsewhere. And so they said, look, we've got a wide suite of objectives. The current system is not serving that. So we want a broad consultation on how we should we go about this to change things. And one option we're not going to consider is what's there now. So I think, they're the first government to do that. We went down this road in the 90s. It's essentially a neoliberal ideology and neoliberal economic theory. It hasn't worked. Hopefully Canada will follow Scotland and, step back from that.
Thank you very much. Mr. Donnelly, I'll address your issue in just a few moments since we're officially into overtime and allowed to be there. First of all, I want to thank our guests for being here today. Mr. Gahn, Monsieur Alain, Mr. Laureline, Madam Laureline, my apologies, Mr. Ruthven, and Ms. Hendricks. Thank you very much. And joining us by video conference, of course, Ms. Tully and Mr. Matson. We appreciate your time today and the expertise and the testimony that you bring. We truly appreciate it. In the meantime, Mr. Donnelly brought up a point about the witnesses and how we're going thus far. Okay. When it comes to the witnesses, what has happened, what has transpired, is that some of the invitations that we've sent out and suggested by you, of course, as witnesses, a lot of them have not been responded to yet. Some of them has said no, and some have not responded. I don't want to get into details as to who they are right now, but what I would suggest is this, since we have some concern around the table. On Wednesday, on the first hour, we have the minister in to talk about the supplementary estimates B. In the second hour, we hope to conclude our study on Atlantic salmon. Following that, can we use 5 to 10 minutes to discuss, because I did say to Mr. Sopak in the last hearing when the minister was present that we would talk about, the witness list is not written in stone. We can be somewhat flexible, but we would like to talk about possible witnesses. Therefore, I ask you to do one thing as a homework assignment. Can you bring me maybe 2 or 3 names that you would like to bring forward? As you know, I don't like this to be written in stone, so I would like for us to talk about it. It will be in camera. And we'll talk about some of the witnesses that we would like to bring in addition to, if we have the space. By Wednesday, we may be able to conclude that there are some spaces available for people who wish to be witness. Mr. Doherty.
Mr. Chair, are you able to provide us with the list of witnesses that are not responding? That perhaps we might be able to contact them if they are indeed witnesses out.
I can do that through your email. We can do that through your email accounts.
Thank you.
Mr. Donnelly, go.
Thank you, Mr. Chair. Just a quick point. Are we needing to go in camera for that, given our new motion?
Well, yes, we're doing the Atlantic salmon study. What I suggested was having it on the back end of that study, which means we would still be in camera. If you feel you want it to be public, you can make a motion at that point to bring it out of camera if you so desire. All right. Anybody else on that issue? Are we okay with that? So just a couple names, and we'll see where we are at that point. I'll take you, yes, indeed, we'll have an update. Actually, when we start, I'll bring an update as to who has responded, who has not. Okay, thank you to our witnesses again, and thank you, colleagues. Adjourned.
Thank you.